Good afternoon. This is the next in a series of programs that we're doing with regard to the Trump administration and the law. It's co-sponsored by the Chris Berkeley Center on Law and Democracy, as well as the law school. As everyone knows, one of the primary focuses of Donald Trump as a candidate and now as president relate to immigration. And so we have two experts on our faculty who specialize in immigration law. And so they're here today to talk about what's happening and what I do about it. Leti Volpp is the Raven Professor of Law. She's been at Berkeley since 2005. David Hausman is an Assistant Professor of Law, has been here for the last few years. Both regularly teach immigration law. I'll turn the program over to them, and I know they'll leave time for questions as well.
I'll just say I'm so grateful to our dean and also to my wonderful colleague, David Hausman, who's going to take it away.
Okay, great. I'm David Hausman. So I've been here a couple of years. Before I was here, I worked for a few years at the ACLU, suing the government over immigration issues. And I want to start with that because I want to be direct today about where I stand on these issues. And this is different, actually, from the way I approach this in class, where I try as much as I can to be neutral and to adopt a position of neutrality. And today I'm not going to be neutral. And I want to be clear that I'm only speaking for myself here. But I think this is a moment that's frightening, and I am frightened. I'm not only frightened, though. I'm also, to some extent, energized by this moment. And so that's kind of my orientation here. And so our plan for today is Leti, Volpp, and I will each take a part of the extremely long list of changes that President Trump has already made to immigration policy in his first 3 weeks in office. And then after we give you that kind of laundry list of changes, we're going to talk about a few of the changes in particular and then open it up for questions. And so with that, let me jump into a list of policies. And to give you a little context here, you might think of these policies in kind of four broad categories. The first category is a new interior enforcement dragnet, so a new way of approaching enforcement on immigration within the United States, away from the border. The second category is changes in border enforcement, including stopping all access to asylum at the border. The third category is a series of withdrawals of protections for people who are already lawfully in the United States. And then the fourth category is a series of planned restrictions on lawful immigration to the United States. So I'm going to just give you a list of actions in those first two categories and then hand it over to Professor Volpp for the second two categories. And I want to say I'm just listing here, and so this is going to be bewildering. And it's intentionally bewildering because the administration is intentionally trying to confuse and overwhelm advocates with its actions. So let me start with the interior enforcement dragnet. So the Trump administration immediately withdrew the Biden administration's immigration enforcement priorities, which were limitations on who the executive would enforce against within the United States. So the administration just immediately removed all those priorities. It withdrew the sensitive locations memo, which limited enforcement, particularly in hospitals, churches, and schools. It then announced really two executive orders, which it described as related to what he characterized as an invasion. So one of those executive orders was really directed towards the interior of the United States, and that did a whole list of things. It prioritized criminal prosecutions related to unlawful entry, expanded the scale of immigration detention, though that will, of course, also require money from Congress, gave other law enforcement officers, like gun and drug agents, the power to arrest and deport immigrants. It signaled that an old law that may require non-citizens to register and get fingerprinted would now be enforced. It imposed sanctions or suggested imposing sanctions on countries that refused to accept deportees. It withdrew or suggested for review Biden policies on temporary protected status, immigration parole, which is a mechanism for people to be allowed into the United States who would otherwise be inadmissible, and work permits. It reviewed and suggested immediately suspending funding for nonprofits who had provided services to immigrants, called for expansion of agreements with states and localities that are so-called 287G agreements that allow states and localities to do some enforcement of the immigration laws. It called for withholding federal funding from sanctuary jurisdictions, and it instructed DHS to expand expedited removal. That's all just this one executive order on invasion. There was actually a new statute as well that was passed in the first week of the Trump administration called the Laken-Riley Act that expands mandatory immigration detention and invites the states to sue the federal government on immigration issues. There was an executive order on foreign terrorist organizations that suggested declaring cartels as terrorist organizations to make it easier for the government to detain and deport immigrants who've interacted with those groups in some way. It asked the same foreign terrorist organization executive order, asked government officials to start making plans to use the 1798 Alien Enemies Act to provide additional authority for mass deportation. That was just an initial suggestion that hasn't yet been implemented. It directed, the president also directed that so-called high-priority criminal aliens be held at Guantanamo, and a few people have already been flown to Guantanamo. Just last night, a court granted a temporary restraining order preventing a few others from being flown there. Then an executive order also directed federal prosecutors to consider the death penalty against undocumented immigrants convicted of crimes who could potentially be eligible for it. So that's a quick list of actions in the interior. It's not a comprehensive list. Let me now move on to the border. I'm obviously just trying to move fast here. So at the border, the president immediately disbanded a task force that had been focused on reunifying families who'd been separated at the border during the first Trump administration. The president announced a new executive order expanding the military's role at the border, directing the military to create a plan to seal the border and tasking it with border enforcement in a fairly undefined way for now. In a second executive order that was directed towards invasion, the Trump administration essentially announced a complete ban on any applications for asylum. In an executive order announcing a national emergency related to immigration, the administration directed that the military assist with government operations at the border, including with building the border wall. And then in an executive order on securing the border, the administration directed the end of parole programs that had allowed some people, particularly from Cuba, Haiti, Nicaragua, and Venezuela, to apply for parole from outside the country and travel to the country. That program was ended. And the administration also announced the end of the CBP-1 program, which I'll say more about later, which provided essentially appointments for asylum seekers to appear at the border. And then finally, the administration also restarted the Remain in Mexico program, which requires asylum seekers to wait in Mexico while their asylum cases are adjudicated, though of course there essentially is no more asylum, so that has limited effect. I'll hand it over to Leti there.
Okay, so I'm going to talk fast because there's so much to cover, and I was exclaiming just in the time it took for me to drive here from my home, there were like 3 more news flashes about changes. So under the category of withdrawing protections for people already lawfully in the United States, well, we could put in that category the parole program for Cubans, Haitians, Nicaraguans, Venezuelans. Also, Trump did end temporary protected status for people from Venezuela. Those of you who know, DACA, TPS is structured kind of like DACA. It's this liminal lawful presence that people have. It's basically, you're already here in the United States and you're told, we will not deport you for a period of time, and we'll also give you work authorization. And so this just ended for Venezuela, and it essentially puts at risk that, or we assume that the administration will also end TPS designations for many other countries as well. Of course, one of the very first acts was to order government agencies to stop issuing citizenship documents such as passports to children born inside the United States on or after February 19th of this year if their parents, if the child did not have a mother or father who was a U.S. citizen or a lawful permanent resident. So I'll say more about that later. There's a executive order on what's called gender ideology extremism, which basically erases protections for and recognition of transgender, intersex, and non-binary people. So government-issued IDs, such as passports and visas, can now no longer allow self-identification of gender, and trans women are to be held with men in prison and immigration detention. There's an executive order called Foreign Terrorist and National Security Threats, which suggests that actions should be taken against non-citizens based on their political advocacy and speech, whether they're outside the United States and seeking admission, so to deny them visas, or if they're already here, suggesting they might possibly face removal. There was a subsequent executive order on anti-Semitism, which makes explicit that non-citizens who have participated in pro-Palestine protests are to be targeted, and it tasks the Secretary of State, Education and Homeland Security to make recommendations to familiarize institutions of higher education with grounds of inadmissibility under the terrorism ground, so universities can monitor and report activities by non-citizen students and staff to lead to their investigation and removal. That executive order also prioritizes resources to take away U.S. citizenship for persons who got citizenship through naturalization, to denaturalize them. That executive order also creates certain restrictions on lawful immigration pathways to the United States. It orders agencies to identify countries for a possible travel ban within the next 60 days. So if you remember from the previous Trump administration, this is teeing up for a situation like we had then with what became known as the Muslim ban and the African ban. The order also asks for persons to be subject to increased vetting and screening, including refugees. In fact, refugee admissions are to be completely suspended, stopping refugees from entering the United States unless government agencies make an exception. And then every 90 days, these agencies are to decide whether to restart the program. There's estimated 10,000 people already approved for travel as refugees who are now stuck outside the United States. One of the things that I saw in the New York Times between leaving my house and coming here was a lawsuit was just filed in the Federal District Court of Seattle about the ending of the refugee admissions program. And it doesn't have an attached complaint, so I couldn't see what the claims were. We can think about the prioritization of refugee admission with the fact that the Trump administration also issued an executive order on South Africa, which directs the prioritization of refugee resettlement in the United States of Afrikaners who are subject to racial discrimination in South Africa. Okay, I'm going to turn it back now to David Hausman.
Okay. All right.
Professor Hausman.
Thanks so much, Leti. So, we just gave you this list. It's absolutely overwhelming to hear this list of actions, and obviously that's the point, right? The point is to overwhelm. And I know that in my reaction to these policies, I felt a lot of confusion, and I've also seesawed a lot in my reaction to these policies. It's very hard, I think, to interpret what's happening right now and to understand what the implications are, because I think we're in a moment of pretty extreme instability where it's very hard to see what's going to happen. And I think part of the reason that there's so much uncertainty is that it's very hard to tell with each action what the action is really about. And so let me say a little more about that. And I think there are really three kind of possibilities. So for each of these actions, it could be that the action is really a large and important swing in immigration policy that's going to cause a lot of harm to non-citizens. That's a possibility for each of these actions. It's also possible that each one of these actions will end up having very little effect. And instead is really symbolic and is about scapegoating immigrants instead of about really changing immigration policy. And then third, I think it's possible that some of these actions really aren't about immigration policy at all, and that they're instead much more about an attempt to seize the levers of government by this new government and essentially attack the rule of law. And trying to figure out which goal each one of these actions accomplish is really difficult, and of course they may be serving all three goals at once. So there's no way to talk about all of these things, so I want to just concentrate on a couple of things, and I want to think in particular about what's really changed at the border and in the interior. So let me start with the border because it's easier to summarize. So first of all, if we think back to the long-lost Eden of the summer of 2019, during the first Trump administration, it was black-letter law that anyone physically present on U.S. soil had a right to apply for asylum. That's clear in the asylum statute. However, that has been steadily eroded over the past 5 years, including under the Biden administration. So the Supreme Court allowed Trump in the fall of 2019 to put in place his transit ban, which made ineligible for asylum anybody who had traveled through Mexico who wasn't from Mexico and who hadn't sought asylum in Mexico. Then we saw an expansion of this with so-called Title 42 expulsions, which were pandemic-related expulsions at the border. And Title 42 actually persisted under the Biden administration until the spring of 2023. Then we saw a kind of reinstitution partially of the transit ban by the Biden administration. And then finally, in June of 2024, a near total asylum ban by the Biden administration, with exceptions only for unaccompanied kids and for people who had made appointments, so-called CBP-1 appointments, at the border. So the situation we had at the border before the election and the inauguration was one of a near complete ban on asylum with some meaningful exceptions, the most important of which was the availability of appointments at the border, a limited number of appointments available via an app, and the result was that hundreds of thousands of people were waiting in Mexico for the chance at an appointment at the border. Within minutes of Trump being inaugurated, all of those appointments were canceled. And that's the most significant immediate policy change at the border with the new administration. So in terms of what actually changed in terms of the availability of asylum, that's the most significant change. The other really significant immediate change is the withdrawal of these parole programs that we mentioned earlier. But of course, lots of other things happened. And in particular, I think sending the military to the border serves no obvious purpose in the context that we're in post, essentially, Biden asylum ban. So we have this near complete ban at the border, and one result, partly a result of that ban, but also of larger trends at the border, is that we really haven't been seeing that many people arriving at the border over the last few months. So sending the military to the border is particularly unnecessary right now. So to me, that feels much more like an action that belongs in the second two categories. It's a scapegoating action. It seems like a possible way to attack the rule of law and democratic norms. Then there's reinstituting the Remain in Mexico policy, which is a policy that requires people seeking asylum to remain in Mexico while they seek it. That strikes me as a policy that's really pretty firmly in the second category, the scapegoating category, because again, the administration has eliminated access to asylum more directly already. Then finally, the recasting of the existing ban on asylum in terms of invasion also seems to me like something that really belongs in the second category, maybe also the third category of attack on the rule of law, because we already had a near complete ban on asylum under the Biden administration. So I think at the border, we have this really important shift in the end of parole programs and the end of CBP-1 appointments, paired with some, I think, very troubling symbolic actions. All right, so turning back to the interior and mass deportation plans. So how should we think about the Trump administration's plan to deport, the administration claimed, millions of people? Are we really on the cusp of a moment of a massive increase in deportations, or are these actions more, again, about scapegoating and taking advantage of immigration to degrade our institutions? And I really don't know. I certainly think we're going to see some increase. What I want to just talk about is the roadblocks to that increase. And those roadblocks are mostly practical rather than legal, though the ways around the practical roadblocks are mostly illegal, and so we'll see whether the administration can get away with them. So there are, I think, three key practical bottlenecks for the administration in terms of pursuing mass deportations. The first one is that it's hard to make immigration arrests. It takes personnel and time. And so overwhelmingly, until now, and actually still now, immigration arrests happen in jails and prisons. So immigration arrests typically happen for people who have already been taken into criminal custody by state and local authorities. But there aren't that many of those people. So as most of you probably know, immigrants are much less likely to commit crimes than citizens of the United States, and there just aren't that many non-citizens of the United States who have been arrested for a crime, let alone convicted for a crime. So you're not going to get mass deportations that way. There aren't enough people. It's just not, it's not a thing. So if you want to deport more people, you're going to have to arrest people in other ways, and that's going to be difficult. That's the first roadblock. The second roadblock is detention space. So once you've arrested someone, in order to effectuate their deportation, you typically need to essentially imprison them. And this is really expensive and difficult, and to date, the government has typically had on the order of 30,000 to 50,000 detention beds available per day. That's nowhere near enough for a true kind of mass deportations policy. And then the last roadblock is deportations themselves. Flying people to other countries is really expensive, logistically difficult. You have to get the other countries to agree to take them back. All right, so since I have limited time, let me just concentrate on the first of these bottlenecks, the arrest bottleneck. The first thing to say is, so far on arrests, we're not seeing huge actual practical changes. So for the first couple weeks of the administration was publishing daily immigration arrest figures, and those were higher than under the Biden administration, but they weren't enormously higher. They weren't higher than during many periods under the Obama administration, for example. And so there was a kind of increase, but not a massive jump, and that shouldn't be surprising, given that this is a really hard thing to do logistically and practically. So let me talk about what the administration is trying to do to change this. The first thing it's trying to do is to do a lot more to deputize state and local officers to make immigration arrests. First, under the so-called 287G agreements, and then there's also an attempt to use a never-before-used so-called mass influx provision. We really don't know how that might work, and I don't think we're seeing that in action yet. But even if we get a lot more deputization of state and local officers to make immigration arrests, it's going to be very hard without other changes for those arrests to result in a lot more deportations. And that's because the people who will be arrested are going to be people who lack criminal convictions, because again, there just aren't very many non-citizens out there with criminal convictions. People who lack criminal convictions can typically be released from immigration detention on bond, absent other legal changes. And so all you achieve by arresting people in this way is you spend more of your detention-bed resources on detaining people for a period of time before they'll be released on bond. So it's in order to actually have those arrests lead to more deportations, a lot more has to happen. Another front that the administration is fighting on is the sanctuary front. And there, this is a real potential policy change. So it's very clear that local sanctuary policies, which make it harder to transfer people from local jails to ICE immigration custody, do have a large effect in reducing deportations. I've done some empirical work on that, and it's just a well-known fact by practitioners. And so the Trump administration is trying really hard to persuade state and local authorities to cooperate with its requests to hold people beyond when they otherwise would be released in order for them to be transferred to ICE custody. And so a lot does hinge on whether that can happen. So when I say a lot, well, this still wouldn't be, enough to get to the scale that the Trump administration has threatened, because once again, there aren't likely to be that many non-citizens in jails because not that many non-citizens are arrested on suspicion of a crime. But still, this could be really important. And so I put these threats in sanctuary mostly in my first category of an important policy change. But then one aspect of the threats on sanctuary has been a threat to actually prosecute local officials who implement sanctuary policies. And that's a threat that feels much more to me like a threat in the third category of an attack on the rule of law, because sanctuary policies have been universally upheld as legal by the courts. And so the idea that local officials who implement those policies would be prosecuted for doing something that the courts have universally held to be legal strikes me as just a clear assault on the rule of law. Okay, the last specific policy I wanted to talk about in terms of interior enforcement, I think falls in the second category, in the scapegoating category so far, and that's the sensitive locations policy. So the withdrawal of this policy that the government won't enforce in schools, hospitals, and churches. And there, so far at least, it's not like we've seen a lot of enforcement in those places. It seems like politically not an obviously sensible move for the Trump administration to start doing a lot of enforcement in those places. And so the withdrawal of that policy seems for now to be in this second category of spreading fear and scapegoating. But of course, we don't know. We don't know. The administration could engage in more enforcement in that way. All right, so that's a sort of impressionistic, very incomplete description of where we are. And I just wanted to end by saying, I realize I'm not projecting a lot of optimism here. Let me try to project a little bit more. So the first thing is this strategy of the administration throwing everything at the wall and seeing what sticks could really be interpreted as weakness. They realize that a lot of it's not going to stick. So they're trying everything at once because they realize that a lot of this can't work, that there will be opposition to it, that courts will enjoin it, and that it does not make sense. So I think that's worth remembering. Then there are still constraints. The courts have enjoined many aspects of the administration's new program. Of course, we'll see whether the administration actually obeys those orders. But for now, there are constraints from the judiciary, and there are political constraints too. People aren't going to like it if their neighbors and friends are deported. So if these policies as threatened were actually implemented, I think they would be hugely unpopular, and there would be a lot of political resistance. And then I guess the final thing is, the flip side of these immigration policies having this kind of triple harm, where they not only change policy, but they also scapegoat and attack the rule of law, is that there's a triple benefit to pushing back against them, where if the Trump administration has to take them back and is stopped, we get these additional benefits for the rule of law as well.
Thank you so much. I'm going to pick up there, and actually the first thing I'm going to focus on, I think, illustrates the triple benefit, hopefully. So I'm going to talk about birthright citizenship, something called expedited removal, and then I'll say something about the Lake and Riley Act, which has been in the news a lot. Okay, so background on citizenship. So to become a citizen in the United States, you can do it through three ways. Two through birth and one later in life. So later in life would be through naturalization. At birth, you can either become a citizen through descent. Essentially, you inherit citizenship from a parent. This is something recognized when a child is born overseas to at least one U.S. citizen parent. The idea is through right of blood. The Latin term is jus sanguinis. The other way you can get citizenship through birth is what's called colloquially birthright citizenship, and this is what the executive order is attacking. The idea here is what is called in Latin jus soli, or right of soil, in other words, birth in the territory. So there's an ancient common law principle that was brought to the colonies that became the United States from England, which is that, quote, every child born in England of alien parents was a natural-born subject unless the child of an ambassador or other diplomatic agent of a foreign state or of an alien enemy in hostile occupation of the place where the child was born. Okay, so you could think of it as, at the time, there was this idea of subjects because there was a king. We have a democracy for now, so we have citizens, right, rather than subjects. So every person born in the territory is a citizen with, as what was outlined in that quote, two exceptions, which I'll say more about. That's actually a quote from a pivotal Supreme Court case addressing this question of birthright citizenship. This idea became codified in the 14th Amendment, which was the response to a terrible Supreme Court decision called Dred Scott, which had held that all people who were black in the United States, whether enslaved or free, were ineligible for citizenship on the basis of their race. Okay, so the 14th Amendment is created, and it states all persons born or naturalized in the United States, comma, and subject to the jurisdiction thereof, comma, are citizens of the United States and of the state wherein they reside. Okay, so it's like this question, what does that middle clause, subject to the jurisdiction thereof, mean? Okay. This case came up before the Supreme Court in 1898 involving a man named Wong Kim Ark, who was born in San Francisco. He had parents who were subjects of the Emperor of China. They could not naturalize as U.S. citizens because of racially restrictive prohibitions on naturalization. At that time, this was specified in the 1882 Chinese Exclusion Act. And he's born in the United States, he leaves the U.S., he returns, and he's told you can't actually physically enter the U.S. because you're racially excluded under the Chinese Exclusion Act, which also limited free movement as well. He said, I'm a citizen, right? So this goes up to the Supreme Court, where the Supreme Court actually reaffirms this idea of universal birthright citizenship. And they note the two exceptions from English common law and one new exception that comes from the U.S. context, which was discussed. All of these were discussed in congressional, you can see them in the congressional legislative history of the 14th Amendment. So these exceptions now are threefold. You were born to parents with diplomatic immunity, right? You can think about this. People who work for the UN don't have to pay parking tickets in New York City. There's like millions of dollars owed to New York. Because diplomats of a certain level don't have to respect U.S. laws if they have diplomatic immunity, okay? Second exception, you're born to parents who are part of an invading army, okay, where the United States is not in control of that territory. Third exception, you're born to a Native American tribe, which is seen as having a quasi-sovereign status, all right? These are the categories that are not subject to the jurisdiction of the United States. Later, congressional legislation was passed to create U.S. citizenship through statute for Native Americans, okay? But those other two exceptions, right, are still possible exceptions that exist. And this language from the 14th Amendment ends up getting codified in federal statute. You can see it in today's Immigration and Nationality Act, for example. So for many years, there's been an attempt to restrict birthright citizenship, right? And again, the focus is who is excluded, right, by that subject to the jurisdiction thereof clause. The targets of this campaign have been children of undocumented immigrants, but also another group. Okay, so John Eastman, who's been a huge proponent of this, has explained he's motivated by the case of Yasser Hamdi, who was taken from Afghanistan to Guantanamo, declared an enemy combatant until it was realized when Hamdi started regaining the English he had learned as a child because he was born in Louisiana when his father was there on a temporary visa working in the oil industry in Louisiana, that Hamdi was a U.S. citizen, and you can't keep U.S. citizens as any enemy combatants on Guantanamo. So this would refer to people on temporary visas who are students, H-1B workers, tourists, et cetera. In a 2023 video, Trump made clear that he's concerned with what has been called birth tourism, right? So he was here suggesting that there would be an executive order issued. He says, quote, "The order will also end the unfair practice known as birth tourism, where hundreds of thousands from all over the planet squat in hotels for the last few weeks of pregnancy to illegitimately and illegally obtain citizenship as a child, to later exploit chain migration, to jump the line to get green cards, and a practice so horrible, so egregious. At least one parent will have to be a citizen or legal resident to qualify. We will restore our sovereignty on day one. Our country will be great again. We will have borders. We will put America first." Okay, so can they do this? All right, the scholarly consensus is that subject to this jurisdiction thereof refers to obedience, right? If you're subject to the jurisdiction, it means you have to obey the law. So Blackstone said the idea is who is subject to the sovereign's power of governing or legislating, right? And so everybody should be included as subject to the jurisdiction thereof, with the exception of people who have diplomatic immunity, or if the United States were ever to be invaded and be subject to the control of some kind of hostile government entity, right, where U.S. laws were no longer the laws being obeyed, right, then children born in that context to members of this invading army would no longer be subject to the jurisdiction of the United States. So the executive order seeks to deny citizenship to categories of people that do not at all align with the scholarly consensus. So again, the executive order prohibits issuing citizenship documents to a child born to a mother or father who does not have a mother or father who is a U.S. citizen or a lawful permanent resident. So essentially, it would deny birthright citizenship to children of undocumented immigrants, as well as children of parents here on temporary visas who have what is known as lawful non-immigrant status, meaning they're on an H-1B visa, they're here as a student, they're here as a tourist, et cetera. This policy was supposed to take 30 days after the date of the order, and it would basically mean that immediately children would be denied certain benefits like Medicaid, SNAP. There were children who would possibly be rendered stateless. Within 24 hours of this order being issued, multiple lawsuits were filed. 22 states, immigrant rights groups, and expecting mothers have all been involved in what are 7 lawsuits. There was a temporary restraining order issued January 23rd by a judge in Washington who said this is blatantly unconstitutional and blocked the implementation for 14 days. On February 4th, another federal district judge issued a preliminary injunction enjoining the order from taking effect nationwide indefinitely and saying, quote, "The U.S. Supreme Court has resoundingly rejected the president's interpretation of the citizenship clause. In fact, no court in the country has ever endorsed the president's interpretation. This court will not be the first." And today, a third judge in New Hampshire also has issued an injunction. The government essentially is trying to argue that we should understand subject to the jurisdiction thereof not to be about obedience, but as to whether or not somebody is under the sway of some foreign power, right? And if you think about it, it doesn't make any sense. It would mean that anybody who is born to a parent who has dual citizenship would not be seen as a U.S. citizen. It also would suggest that somebody born to a lawful permanent resident who hasn't naturalized as a U.S. citizen would not have U.S. citizenship, but they want to give citizenship to children of lawful permanent residents, right? So there's this complete misalignment between the categories of who they want to give birthright citizenship to and to deny it to, and what the law would require. I think many of us had assumed that when the president declared there was an invasion, that invasion would play a larger role in the briefing of these cases, but actually, interestingly, it's not there. The kind of warning that this might happen came because Judge James Ho, who's a circuit court judge who actually was a very long-time defender of birthright citizenship, is among the list of people always say, oh, if there's going to be a Trump-appointed new Supreme Court nominee, perhaps it will be James Ho. He recently, in an interview in the fall, had said, well, if we think about children of invading armies, and we see that there's an invasion of the United States by so-called, by undocumented immigrants, this would suggest that those children should not get birthright citizenship. But I think we have to be very clear that when you look at the Wong Kim Ark decision and the language in that case, who they're talking about when they're talking about invasion does not mean what Trump means by invasion. He can call something an invasion. They're talking about a context where a hostile government has essentially taken over a particular territory, right, and is the law of the land. They're not talking about a situation where you have people who are physically present who are subject to the laws of the United States. That cannot be called an invasion, right, that would deny a child birthright citizenship. So essentially, we have a situation where the executive branch is pretending it has the authority to rewrite or nullify a constitutional amendment whose meaning has been recognized repeatedly, both in federal statute and multiple court decisions. It's never been interpreted otherwise. So I might put this in the category of the symbolic act. Okay, secondly, expedited removal. Expedited removal basically was created in 1996 by Congress in a law called the Illegal Immigration Reform and Immigrant Responsibility Act. There was a 60 Minutes program where they showed people who were flying to Kennedy Airport and then didn't have a visa, right, and they were getting released in the United States and then told to show up for a removal hearing. And this caused this kind of furor in Congress, which said we need some kind of very quick, expedited, summary means of excluding people from the United States if they're showing up and they either have no visa, right, no lawful means on which to enter in the United States, or we think that they've engaged in some kind of fraud or misrepresentation. So Congress created a system called expedited removal. There's standard removal proceedings, which have a certain amount of process, right, for non-citizens. In standard removal proceedings, a non-citizen gets a hearing before an immigration judge. They can present and cross-examine evidence. They can call witnesses. They have the privilege of being represented by an attorney or other representative. It's not like a criminal proceeding. You don't get a government-paid attorney. You have to basically find your own and pay for your own attorney or some kind of representative, but you're allowed to have one, right? You can demand reconsideration or reopening of the case. You can appeal an adverse decision. Expedited removal has none of those protections. Non-citizens who are subject to expedited removal are ordered removed by an immigration officer without further hearing or review. The only kind of backstop is if the non-citizen says, I fear persecution, right? I fear torture, right? In which case they're to be given what is called a credible fear screening. If they pass that screening, they then get put in regular removal proceedings, right? And get the protections of regular removal proceedings. So when Congress created expedited removal, they basically authorized it for people applying for admission at a port of entry and also clarified that the Attorney General could apply it to persons already who had already entered the United States but never been officially admitted, right? So those who had entered without inspection after the Attorney General affirmatively would designate who would be included in this category. So there's been this kind of encroaching series of incursions as to who expedited removal applies to. From its creation until 2002, it applied only to arriving aliens at ports of entry. Under the George W. Bush administration, they expanded it to people who were already inside. If they had arrived by sea. You can guess who that was intended to apply to, namely Haitians, right? In 2004, it was expanded to those who were already inside, right, the United States, who had been encountered within 100 miles of a land border, who could not demonstrate that they had been in the U.S. for more than 14 days, okay? And then in Trump's first term, he expanded it to anywhere in the United States, not just 100 miles of a land border, anywhere in the United States, against anybody who could not prove that they had been continuously physically present for the past 2 years, okay? So Trump did that in his first term. It was litigated. It was mostly tied up during that entire administration, and then President Biden rescinded that expansion. Now Trump seeks to apply it again to anybody who cannot show they've been here over 2 years who's arrested anywhere in the United States. Okay, so a lawsuit was filed January 22nd by the ACLU. The plaintiff is Make the Road New York. There are various claims for relief, including Administrative Procedure Act claims and constitutional claims, which I want to say a tiny bit about. Basically, there's a long line of cases that recognizes that persons who are inside the United States who are being put in removal proceedings because they're already inside should have procedural due process, right? And remember, procedural due process is how something is done, and we can see that that constitutional guarantee has been codified by Congress in those particular protections in regular removal proceedings, right? All the notice, the witnesses, the evidence, et cetera. There was a 1903 Supreme Court case called Yamatai versus Fisher, where the court said in this case, therefore, it is not competent arbitrarily to cause an alien who has entered the country and has become subject in all respects to its jurisdiction and a part of its population, although alleged to be illegally here, to be taken into custody and deported without giving him all opportunity to be heard upon the questions involving his right to be and remain in the United States. No such arbitrary power can exist where the principles involved in due process of law are recognized. Okay, so that was 1903. That's been the governing understanding of how to think about this. Over the past years, the government has been trying to chip away at the bright line rule or the bright line that exists between people who are considered outside, who don't get due process, and people who are inside, right? And they had started to argue things like, well, how long was this person in the U.S.? How far away from the border were they found, right? Are they to be treated as an arriving alien or as somebody who's already here, okay? The most recent pronouncement of this was 2020, the Supreme Court in a case called Turcidium, where this Turcidium was found 25 yards within the United States, right? So close to the border, 25 yards when he was apprehended. Justice Alito decision, he was treated for due process purposes as if stopped at the border. To conclude otherwise, the court warned, would undermine the sovereign prerogative of governing admission to this country and create a perverse incentive to enter at an unlawful rather than a lawful location, right? So how do we understand the consequences of that case? Where will the line be drawn as to who is on the threshold of entry and who has established connections with the country when we're thinking about how a constitutional challenge to expedited removal, right, people who are inside, right, will be understood. In the meantime, the recommendation, what to do, carry a copy of evidence that you've been in the United States for longer than 2 years, right? If you're concerned that you might be stopped and they might assume that you're a non-citizen and that you do have a history of lawful entry or status, you should carry evidence of that with you. You should not carry foreign identification documents, which will be taken as a sign that you are a non-citizen, right? Okay, last thing I want to quickly talk about is the Lake and Riley Act. This was signed into law January 29th. It was named after a nursing student who was killed by a man who was an undocumented immigrant with a history of shoplifting arrests. It follows a long pattern of Congress passing immigration laws with very dramatic consequences for many people in response to a tragic case. It's in line with the Trump administration focus on so-called criminal aliens, migrant crime. In his previous administration, he coined the term angel mothers to refer to parents who had lost children who were killed by undocumented immigrants. What does the Lake and Riley Act do? It expands mandatory detention, meaning there's no possibility of individual determination whether somebody's a flight risk or somebody's a danger to society for non-citizens in immigration proceedings. It also purports to give states the ability to sue the federal government over immigration decisions, essentially flipping the idea of federalism, that immigration power is for the federal government. I'm going to talk more about the first, the mandatory detention question. Essentially, the Immigration and Nationality Act already requires certain non-citizens to be mandatorily detained once removal proceedings have been commenced. And it's a categorical determination based on why is this person facing immigration removal. If it's under certain criminal or terrorism grounds, the person does not qualify for an individual bond hearing. If you're not being detained under one of those provisions, you can get an individual bond hearing before an immigration judge who will decide, well, can I release this person pending, while their proceeding is pending. So the Lake and Riley Act expands who faces mandatory detention to include non-citizens who are inadmissible because they're present without admission or having been paroled, or they've committed misrepresentation or they lack entry documents, okay? You can think of that synonymously as non-citizens who are undocumented because they entered without inspection, right? So it applies, the Lake and Riley Act expands mandatory detention for undocumented immigrants who entered without inspection, who also are, quote, charged with, arrested for, convicted of, or admitted having committed or admits committing acts which constitute the essential elements of burglary, theft, larceny, shoplifting, or assault on a law enforcement officer, or any crime resulting in death or serious bodily injury to another person. So there's been a lot of reporting saying that the Lake and Riley Act is a deportation law. It's actually about detention. It does not add new categories of deportability. It basically means that events prior to a criminal conviction could trigger mandatory arrest and detention. You could have a situation where somebody is arrested for shoplifting. Typically, they'd be released on their own recognizance, but now ICE could detain the person, initiate removal proceedings, and complete them even while the shoplifting case is pending. It's possible the person could get deported even before they're formally criminally charged. Okay? Note that by definition, anyone subject to Lake and Riley Act mandatory detention is inadmissible and therefore removable under the immigration law. The question is, would they have been somebody put in those proceedings, right? So this is about kind of expanding this dragnet, like this enforcement power of who is facing deportation. Obviously, there are huge due process concerns. The idea of prolonged detention without access to individual bail or bond hearing possibly being done because of an individual accusation. ICE has said that the Lake and Riley Act is impossible to carry out within its current budget. You heard from Professor David Hausman how many people are being detained. ICE has said they would need to detain an additional 110,000 people under this law, which would estimated costs would be $86 billion over 3 years. Notice that over 90% of people in immigration detention are actually in privately run for-profit prisons, like, for example, Geo Group and Core Civic facilities. So what to do if you're or advice you might give to somebody: do not admit committing crimes. Remember, people have the right to remain silent. If somebody's charged with any of the crimes listed in the Lake and Riley Act, they should tell any criminal defense attorney about their immigration status. We anticipate there will be legal challenges. For example, a challenge based on the argument that somebody who's detained does not come within the class of people described in the Lake and Riley Act. The act basically says the definition of theft, burglary, et cetera, is supposed to have the meaning given in the jurisdiction where the act occurred, but the federal law of immigration is supposed to deport people not based on these local definitions of acts, but on this kind of universal federal definition of what these crimes mean in terms of whether they have immigration consequences, right? So there's kind of a collision course between those two things. We also can assume that there would be substantive and procedural due process challenges under the Fifth Amendment. Okay, so again, just to say, I recognize this is all very, very overwhelming, and as David Hausman said, this is strategic, and I think my advice to you and to myself is to just try to stay calm and stay focused on the particular pieces if you feel like you can make a difference, because otherwise it just feels like, you know, you want to crawl in a hole.